Hey there, I'm estate planning attorney Paul Rabelais, and in this video we're going to talk about the different ways a parent or parents can leave their estate to their heirs. And we want to emphasize on making sure you do it in a way that avoids conflict in the future, avoids your heirs losing their inheritance due to a subsequent divorce, or maybe even in some circumstances making sure your children avoid blowing their lump sum inheritance that they may receive. So we're going to address not only who will inherit from you, but how they can inherit from you as well. First, let's talk about who, and we're talking really in terms of, I know some people don't have children, but really we're going to focus on that parent, maybe that single parent who's trying to decide, yes, I have children, I have grandchildren, who and how should I leave my estate to them? But at the same time, we're focusing on that married couple who's trying to figure out, after we both pass away, who's going to inherit from us and how they will inherit from us. So I'd say the default is clearly we want to leave our estate to our children equally. You have 3 children, leave them each 1/3. That's the default, very common. And so some parents will even say, yeah, we want to leave it to our children equally, but we also want to make sure that if one of our children dies before us or predeceases us, we want that child's share to go to our child's children. So all of that is very, very common, and sometimes you'll see that phrased in legal documents as leaving your estate to your descendants per stirpes, which means leaving your estate to your children equally. If a child predeceases you and they have children, child share goes to the child's children. If a child predeceases you and they don't have children, the child share goes back to your other children. So very common, descendants per stirpes. Sometimes, however, parents will leave their estate to their children and it's not equal for a variety. They'll justify it for a variety of reasons. Maybe they'll say, this child just needs more than the other 2. They've struggled throughout their lifetime. We're going to leave more to that one child. Sometimes people will say 2 of our children have nice homes. Our 3rd children just has never been able to own a home. So we're going to leave our home to that child so they'll all have a home. Sometimes people will say, we're going to leave less to this one child because we helped out that child more during that child's lifetime. Maybe the parents bought that child a home. Maybe the parents paid for that child's medical school education. Maybe the parents gave a big sum of money to the child so that the child could start a business. And so you see that sometimes. Or sometimes you'll see people say, especially older parents may say, you know what? Our daughter, 15 years ago, she quit her job to take care of us. Now we're 90 years old, and that child has really sacrificed and done a lot for us, so we're going to leave more to that one child for that reason. So there's really an unlimited number of reasons why parents sometimes provide more or less to certain children than the others. But I'd say clearly the default, the most common, is leaving the estate to the children equally. However, people also have grandkids, and so they wonder, should we leave an inheritance to the grandkids? And so what goes through their mind is, should we just leave our estate to our kids and then let our kids take care of their own kids? Or, when we pass away, do we want to carve something out specifically for the grandkids? So if you're, thinking maybe we should leave something for the grandkids, there's a couple of different ways to do it. If you're really just kind of acknowledging the grandkids, maybe you have a $3 million estate and you just want to kind of acknowledge those grandkids. Maybe you'll put in your estate plan, I leave $10,000 to each of my grandchildren, or I leave $25,000 or $50,000 to each of my grandchildren, and I leave the rest of my estate to my children equally. So when it's that kind of minimal acknowledgement, it's often a dollar amount. But on the other hand, you can leave them a percentage of the estate. Had someone tell me recently, Paul, we want half of our estate to go to our grandchildren when we pass away and half of our estate to go to our children. So when you're going to make them a kind of major heir or major beneficiary, maybe a percentage is more appropriate because you don't know how much that estate is going to fluctuate from now until you pass away. And I will say that while you certainly have the right to leave a portion of your estate to charities or to individuals who are not related to you, really the focus of this is for those parent or parents who really want to kind of leave the estate in the bloodlines. On another note, I will say we have to be particularly careful with those blended families, and you have to look at this one closely. So let's say husband has 2 children, wife has 3 children. So after both of the parents pass away, what do they want to happen? Some parents will say, well, we just want, everything to go 5 ways equally to our 5 children. Other parents in that situation will say, yeah, well, the husband's portion of the estate should go to his 2 children, and the wife's portion of the estate should go to her 3 children. However we do that, we have to pay particular attention to what happens from the time that the first spouse passes away until the time that the second spouse passes away, because oftentimes things get locked in when the first spouse passes away, and that surviving spouse has the opportunity and ability to change the distribution schedule of their estate. So you got to be careful with that, particularly with blended families. Okay, so that's the who will inherit from you. Maybe just as important as that is how those heirs, children, grandchildren, will inherit from you. I'm going to say there's 3 ways, if I'm going to categorize it, 3 ways to leave your estate to your heirs. First one, real simple. Everybody understands it. Leave it to them outright. When we pass away, husband and wife, we want our estate to go to our 3 children equally. So it's outright. They get it in a lump sum. They receive their inheritance. Let's say the parents pass away, $3 million divided up. Each child gets $1 million. They can do whatever they want to with it. Real common, that's leaving it to them outright, or sometimes we say leaving it to them in a lump sum. And a lot of parents kind of at first impression think that's kind of the only way to do it, and there really doesn't need to be any other options. But let's just, for fun, let's talk about a couple of other ways you can leave an inheritance to children, grandchildren, or even others. Some parents really like the idea of a little extra protection so that their children are further protected in the event the child receives an inheritance and then gets divorced. So I will say, at the moment your child receives that lump sum or outright inheritance, it's theirs and theirs only. But the problem that happens often is sometimes your child who receives an outright inheritance will often commingle or mix up that inheritance with other assets they may have with a spouse. And then if they get divorced, they lose half or more of their inheritance. So there's this second option of leaving their inheritance in a trust. You're not doing it to try to restrict them from having the ability to access it, but you leave it in a trust for them, perhaps even name them as their own trustee. Let's say you have a son, Timmy, and so you leave Timmy's 1/3 to the Timmy Trust and name Timmy as the trustee. Now, perhaps you even give Timmy the authority to take assets out of the Timmy Trust at any time. So he could, really kind of undo that trust and commingle those inherited assets with other assets Timmy has with a spouse. But a lot of parents like the idea of, let's set it up so that when we pass away, assets go into the Timmy Trust. And it's really a little harder than for Timmy to commingle those trust assets with other assets Timmy may have with a spouse. So as long as Timmy just keeps those assets in his trust, if he gets divorced, he keeps his trust. Timmy and spouse split other assets that they may have acquired together. So many parents really like that idea of the kind of divorce-protected trust that they're leaving for their children. Like many parents say, we like our son-in-law, we like our daughter-in-law, but the words I hear all the time are, you just never know. And then the third way to leave an inheritance to your children, and this is more appropriate when you just don't want your child, whether they're an adult or not, you don't want them getting their hands on a lump sum inheritance and having the opportunity to blow it. So this is where you leave the hypothetical Timmy's inheritance to, I'll call it the Timmy Trust, and name someone other than Timmy as the trustee of that trust. There's some other options. You can name Timmy as a co-trustee or have multiple trustees. So you leave Timmy's inheritance to a trust, and maybe in the back of your mind saying, I just don't want to dump $1 million, or it might be $100,000, or it might be $5 million. I just don't want to dump it all in Timmy's lap right away. I don't think that's the best way to do it to ensure that Timmy's inheritance will benefit him for the rest of his lifetime. So you'll leave Timmy's inheritance in a trust. You'll name someone else as the trustee, maybe a trusted friend or a relative, or maybe even a trust company to be the trustee, and you put provisions in the Timmy trust to determine when it can be doled out to Timmy, under certain circumstances. So there's a whole bunch of different options on when you do leave it in a trust for Timmy and you name someone as the trustee, when Timmy can get to that buddy. I will say, before we talk about when these trusts terminate and Timmy gets the money, probably worth mentioning that, I'm going to jump the gun a little bit. Let's say in that trust you said that Timmy can have the inheritance when he's 50. Well, under all of these options, most parents typically make a provision in the Timmy trust that if the trustee determines that Timmy needs a distribution for Timmy's health, education, maintenance, or support, then the trustee has the option or the discretion to make that distribution to Timmy or to a third party on Timmy's behalf. So if Timmy really has a reasonable need, the trustee can take care of that. But that aside, when does Timmy get the rest of the money? Some people say, let's put an age on it, when he's 50. Some people say, let's give it to him in stages. When he's 40, he can have a third. When he's 50, he can have 1/2 of what's left. When he's 60, he can have the remainder. Some people say, you know what, and we see this a lot when a child has maybe some chemical dependency issues. Parents may say, well, we have no idea what Timmy's going to be like when he's 50 or even when he's 60, because he has his ups and downs. So those parents may say, I want to let the trustee determine in the future when it's appropriate for Timmy to receive the assets, when the trustee determines that he's in a good space and he's financially mature enough to handle it for himself. Sometimes parents will say, well, I like the idea of giving Timmy 4% of the principal every year. That way he gets a distribution based on how much the inheritance is and the way it's invested and all of that. And maybe that distribution goes up a little bit every year. Sometimes parents will tell me, Paul, Timmy is going to need $4,000 a month to live. So let's make sure that after we pass away, Timmy's portion goes into the Timmy trust. We'll name so-and-so as the trustee. The trustee is directed to give Timmy $4,000 a month. And then there's a couple of other nitpicky decisions of whether you make that $4,000 monthly distribution, whether you adjust it for inflation every year. So every year that distribution goes up. And again, that distribution goes on year after year until Timmy's inheritance runs out. And if we're going to get a little bit more nitpicky, you may not pass away for 20 years until after you set all of this up. So is it $4,000 is a month is what he gets in the year that you pass away? Or do you want that $4,000 figure adjusted for inflation from the time that you set all of this up? So if you pass away in 20 years, maybe in that year you passed away, Timmy's distribution could be as much as maybe $5,500 a month because it got adjusted for inflation from the time that you created the estate plan. So those are some of the options on who can inherit, how they will inherit. Hope that helps. We'll see you next time.